Hello, everyone. Thank you so much for joining us today. We are doing Understanding Titles webinar, and we're fortunate enough to be joined by Damien Meardi of Henning Byrne, LLP. Also fortunate, Damien has been kind enough to partner up with our office and always provide some great advice and is always open for questions. So, Damien, thank you for joining us today. The floor is yours.
All right, let me, I think that's it. All right, so I'm assuming everyone has me here. Okay, so for those that you don't know me, my name is Damien Meardi. I am a partner at the law firm of Henning Byrne. A bit of background about me. I started with Henning Byrne as a student back in September of 2012. Before that, I worked as a small business development consultant and spent some time as an analyst with the federal government. I currently practice in the areas of residential and commercial real estate, corporate commercial solicitors work, and I do some wills and estates as well. For those that haven't dealt with me on a deal, I thought I'd go a bit about over my process when I receive a file real quick. It can be best summed up as I think about what I would want from a lawyer if I was a realtor or a client, and that's what I try and do. So in some offices, clients only deal with the assistants. They may never even actually meet the lawyer or even speak with them. I make it my practice to be the point of contact for the client. I will be the one answering the questions and I will be the one meeting them. I will generally contact the client within a day or two of receiving a contract or their contact information. In my experience, this gives them a level of comfort moving forward, and this is especially true if they're a first-time home buyer. After contacting the client, I will send a follow-up email going over what we talked about on the phone. I'll CC the realtor so they know that we've been in touch and that things are moving forward. And I will return calls when I get messages. So I'm a big believer that service industry, that service should be a big part of that. And getting a hold of your service provider when you have a question is fairly important to what my process is. I will generally meet a client whenever and wherever is convenient for them. So this is especially helpful if your clients are a young family or the elderly. They shouldn't have to take time off work or brave the elements or haul their kids down to a lawyer's office for something that can be completed in the privacy of their own home. And then on possession day, what happens is if it's for a purchase, the client and the realtor get an email from me saying we're funded, we're good to go. And if it's a sale, they just get a text from me saying, you know, when you can release keys. So today, now that we've got that out of the way, we're going to get into a bit of a discussion about titles. And I'm going to try and have a bit of a chat about some things that pop up from time to time. Unfortunately, we're not going to have near enough time to go over everything that can arise. But if anyone ever has any questions about something odd on a title or something you see, feel free to give me a shout.
And Damien, on that point, Damien, to all the attendees, you will see in the bottom corner, you'll see a question and answer or a Q&A. If Damien's talking about something that you have a question of, just type your question in there, and then I will ask it on your behalf. And then if it's answered, we'll continue going on. And if not, we'll just save it for the end once we open up the mics.
All right. So first, I'm going to provide a bit of information about permitted versus non-permitted registrations. Then we'll be going through a few examples of titles related to mortgages. We'll discuss some issues related to caveats and liens. And finally, we'll discuss a couple of other security interests that you may come across. So when it comes to permitted versus non-permitted registrations, when I look at a title, I'm pretty much looking to answer one question. That's what do I need to promise to complete the sale? And inversely, if I'm acting for a purchase, what do I need the other lawyer to promise to do in the purchase? So every lawyer's trust letter will have a list of permitted and non-permitted registrations. Permitted registrations on title will be things like utility rights of way, party wall agreements, stuff like that. And these things are going to stay on title after the deal. Non-permitted registrations will be things like mortgages or liens that must be discharged. Now, I don't really pay too much attention to permitted registrations, as they don't really require any action. It's the non-permitted ones and those that are in the gray area that are more of a concern for me. So as a seller solicitor, I have to promise to have those removed. So if it's a mortgage or any kind of debt, I have to ensure that there's enough money to pay off the debt and your commissions, or I can't proceed with the deal. In shortfall cases, I would actually have the client bring in funds before I send documents to the other lawyer. And I do this because if I can't keep my promise to remove those things, it puts my practice at risk. So this is why also that sometimes you'll see a deal delayed because the seller's lawyer can't get a payout from the lender in time. So they don't have enough information to make that promise to remove the registration. So they wouldn't allow the buyer's lawyer to use transfer documents until they're in a position to make that promise. Now, when I'm acting for a purchaser, I want to make sure the seller solicitor promises to remove all non-permitted registrations that I need removed in order to complete my duty to the seller. If the seller's lawyer promises to remove the registration from title, I really don't care too much about what it is because it's not my problem. It's going to be their problem. The one big exception to that is if it looks like there's clearly going to be a very large shortfall or they're way underwater, I may contact the seller's lawyer to confirm that the deal will be proceeding. But other than that, I don't spend too much time on those. The permitted registrations are the ones that I would spend most of my time on. And I will want to make sure that all of these registrations on the lawyer's permitted list when he sends me the letter or she sends me the letter are actually permitted. So there are times where there's a bit of a gray area here. So it's not immediately obvious if a registration is permitted or not. I'll pull a copy off spin and have a look. If the registration I feel is something that should come off, I'll contact the seller's lawyer to discuss. So now we're going to look at some actual titles, and we're going to start with some issues that I generally see pop up with mortgages, unless there are any questions right off the bat, Alex.
There's one question just about shortfall. At what point is a shortfall discovered? Before or after the payout statement is provided?
After. Yeah, so I mean, you can kind of tell by looking at the title. So, and unless it's like a collateral mortgage, because sometimes those will register for quite a bit higher than the actual mortgage value. But I can usually tell, you know, by looking at the title whether they're going to be underwater or not. You know, if they just registered last year for, you know, $50,000 more than what we're getting for the cash to close, I pretty much guarantee that's going to be, you know, they're going to be a bit underwater. But we have to. I need the payout generally. To long story short.
Yeah. And most financial institutions now are doing collateral mortgages, correct?
You know, it depends. So TD always. Yeah. Scotiabank's about half and half. RBC probably a little more in the other way. And a lot of the non-traditional lenders will still be doing traditional mortgages.
Okay. And just for the difference for everyone listening, a collateral mortgage, they typically go at 100% of purchase value up to 115. And it stays as a flat number, where traditionally it was actually the amount of the mortgage that was put on or registered, correct?
Correct. Well, and there's a couple other differences, but the registration amount will be a little different, but that's kind of, I guess, the crux of it.
Yeah.
So the first title is probably the most common mortgage issue that I see with mortgages on title, and this is the paid out mortgage. So when individuals pay off their mortgage, the bank provides a letter and a registrable discharge. At this point, people usually celebrate, and they may have one of them mortgage burning parties you see on TV. The problem is that there's one more step for the homeowner to complete, and that is to register that discharge with the land titles office. In most cases, by the time we see the deal and pull the title, the seller has long since lost the letter and the discharge, or burnt it or something. And this can cause problems because I need to ensure that the title is removed, or that the registration is removed from title. Sometimes lenders will have a tough time finding records from 20 years ago, so it can be difficult getting written confirmation that this mortgage debt is actually paid. I've had one sale over the years where the lender didn't even exist anymore. They think they had sold about 5 or 6 different times to 5 or 6 different companies. And we ended up having to go to court to get this thing removed from title. It was from 1964. More often, the way it works is that the client or my office will spend a lot of time on the phone and with the bank trying to track down the account and confirm that the mortgage is indeed paid off. Then once confirmed, we recommend that the bank send us a registrable discharge. In these cases, if I can't confirm the mortgage is paid off by closing day, we have to hold back enough funds to cover whatever's registered on title. So, this one you're looking for here, this is, I think last year this deal was, I'd have to hold back about $66,000 from my client until I can confirm that this mortgage, which is obviously paid off, is actually paid off. But unfortunately, I need something in writing. The earlier, so the way that works is the earlier in the process we identify these issues, the better off for the client. And the easiest way to identify it is to have a quick look at the mortgage information. So in the example that I have up here, we have one registered in 1984 for $64,975. Obviously, it's been paid off and never been discharged. However, due to the age of the registration, this is kind of one of the ones that would most likely take a lot of time to fix because the bank may not have a digital record of this thing, in which case they're going to be searching for a while. Now, they're not always this obvious, but if you see a mortgage that was registered quite a while ago, it's a good idea to bring it up with the client and just let them know that there is something on title. It will allow them to contact the lender and get in the process of having the item removed started. This will help ensure that the clients get all of their proceeds on closing day versus waiting for confirmation from the lender and potentially having their funds tied up for a while. So I've included the next one here. This is kind of, the land titles office just started doing this. So I figured I'd include it just to show what we see these days versus, kind of what we just saw in the last one. So this title, we got a mortgage with Scotiabank. We got a mortgage with CIBC and what looks like a line of credit with CIBC. But it's not really that much of a concern for me because if I look at the pending registration queue just below, I can see that there has been a discharge registered for a Bank of Nova Scotia mortgage. So I know that's on the way out. I don't have to worry about that anymore. It used to be that we would have to search pending registrations to see what was in the queue. But now they have them on title for us, so it makes things quite a bit easier to figure out what's going on at any given time. Now, this feature isn't just listed to mortgages or discharges. It'll actually show up, any pending registration will show up here. So, you can see anything really, caveats, dower releases, power of attorney, anything that's in the pending queue will show up there and it'll give you an idea as to what's happening right now with this title. So it can help a lawyer or a realtor for that matter identify any issues quickly. All right.
Another question.
Sure.
How long are registrations usually pending? Or how long do they
Right now,
stay?
3 months.
3 months.
Yeah, land titles, when I first started this business, it was about 5 days. And then it went up to 2 weeks and it stayed at 2 weeks for years. And then from probably mid 2020 till now, they've dropped steadily behind, and we're looking at about 3 months now. Which, and we'll kind of get to that a little later. Thankfully, it's not as big of an issue because we can close things via protocol, but certainly for new condos and any kind of commercial deal, it can come up to be an issue.
Another question popped in while you're talking about that. Would the expectation from you to me / us as agents be to determine this during a listing presentation, a shortfall?
No, I think more than, like, if we're talking about the old mortgage type thing, or for shortfall total?
I'm guessing on funds to close.
You know, I'm seeing a lot more brokerages require the client to bring in money in trust before they'll even move ahead. I don't think that's necessarily, for me personally, that's I have to do that. I don't think necessarily real estate brokerages would have to collect that money, but for me, since I'm the one making the promise, I have to know. When you're doing a listing presentation, you know, you can maybe bring it up. I mean, it's hard to say. If do you guys pull title before you do the listing presentation?
Depends on the associate. Title definitely needs to be pulled before the listing can go live, because we have to ensure who the actual owners of the property are.
Okay, so I wouldn't expect most people to be able to just quickly look at something and figure out whether something's underwater or not until you actually have, like we were talking earlier, a payout statement. So it's not something I would expect necessarily to be handled in a listing presentation. But certainly, I don't know how you guys would broach the subject if you saw something on title, like an old mortgage register. I mean, I would bring that up with the client as soon as possible if I was a realtor, saying, hey, look, just so you know, you got a mortgage on title from 1984. I mean, has that been paid off? And then we can get the process started on that. But certainly for things that are underwater, it'd be tough to tell at that point.
Right. Yeah, and the associate can always ask for a mortgage payout statement to ensure that the property can actually be sold. That can be part of their due diligence as well. And that could be
yeah, or even, I mean, most people are going to have a pretty good idea what they owe, minus whatever the payout penalty is, which again is not that hard to, you know, at least come up with a guess on. So I would think, I mean, do people tell you guys or girls, I guess, what when they're underwater, or do you have to kind of tease it out of them?
Depends on the client. Depends on the client and how open they are to it. To answer Seed's question, in my opinion, it falls on both. It falls on the listing agent's due diligence ahead of time, and it then obviously falls on the lawyer to pay out and close the file to ensure.
Yeah, and most of the time it's not a problem. I think I've had one time where a deal fell apart because of that, and I was dealing with a lawyer on the other side who didn't really do any real estate. I think he had just was maybe his first file in a number of years, and it looked to me like it was underwater. So I asked him, like, hey, are you going to be ready to close this? Like, is your guy bringing in money or what? And it kind of occurred to him, like, holy crap, I got to get money out of this guy. And the deal fell apart because the client could come up with, you know, 20 grand or whatever it was. So which didn't, I mean, I was working for the buyer, wasn't that happy about it, but what are you going to do?
Yeah.
Okay. So the next one that you'll see pop up every once in a while, and I could have added to this to the caveat portion of the presentation, but most of the time when I see these, they end up being debts. So here you have a caveat that is related to an agreement charging lands. So even that it's not listed as a mortgage, most of the time this is almost what I would call these things. A lender can add a charging clause. I mean, I could lend Alex money and do a promissory note and add a charging clause to my promissory note that allows me to register that on title. And this is what it'll show up like. So essentially, a lot of times it's a debt. So it allows the lender to register the debt or whatever the agreement is for against the land. Most of the time you'll see these, it'll be a private loan or some sort of bridge loan. In this case, it's a CIBC mortgage or CIBC agreement, which I'm guessing would be related to a line of credit, but I'm not too sure. In any event, when I see an agreement charging lands on title, I pull the agreement to see what's in it. If it's a debt, I have to ensure it gets paid off. If it's something else, what the agreement's going to say or what it relates to is going to dictate how we deal with it. All right, so moving on to some caveats and liens. Caveat's just an interest in property that has been registered on title. Generally, caveats and liens are non-permitted and must be discharged. So the first one we see here is a vendor's lien. And this just means that there's a seller out there that has an interest in the property. you don't really see these too much anymore for residential deals, because everything is closed now by what is known as Western Protocol. And this is where we don't actually have to submit a transfer for registration until we've already paid the seller. I just have to know that there are no intervening registrations pending. We submit it on closing day, and then the seller actually gets registered on title 3 months down the road. Without this system, it would be impossible to close the deals quickly. I mean, with current land titles delays, I would be meeting with clients again 3 months before closing date. So we'd have to be instructed by the lender 3 months before closing date and have all that stuff done well in advance. But back in the day, you might have seen one of these, because the purchaser may show up on title before any funds change hands. So this was registered to protect the seller. Some of the old school lawyers out there will still register these from time to time, so they might pop up. On residential deals, you may see something like this, where there's some sort of vendor take back or rent to own situation. A vendor's lien and a purchaser's lien, for that matter, would be a little more common in commercial deals, where the purchaser or the vendor want to make sure that their interests are protected until the deal is actually closed. All right. So I imagine most of you have seen a builder's lien. They're not especially novel, and they can certainly show up even before there's any dispute. So if I'm acting for a seller, and here we got a builder's lien registered for about $5,800, I'm acting for a seller, I would discuss with my client whether or not there's actually a dispute here. Sometimes it's just a matter of there's only so many days that you have to register these things, and sometimes contractors will automatically register them right away. And that's not a problem. If it is, we pay it, or the client may have already paid it, and we have it discharged. If there is a dispute over the work or the amount, one of the options available to us is just to pay the court, or pay funds into court, have the lien removed pending a resolution. So this would allow us to proceed with the transaction as the money to satisfy this lien is already with an impartial third party. And then if the contractor wins a dispute, he or she would get funds out of the court. And if the seller wins a dispute or prevails, then the funds would be released to them. The other thing with these is, there's nothing stopping me as just a person on the street from registering this against any title. I don't have to, I have to swear an affidavit, but I mean, that doesn't always necessarily mean it's the truth. So what you can do, one of the things you can do if your a builder's lien shows up on your place or a client's house, is you can submit what's called the notice to prove lien. And sometimes that'll make these things go away. The other option is they actually have to start an action within 180 days of registering this. So if it was registered quite a while ago, you can just have it discharged automatically.
So Damien,
yes, sir.
On some infill builders, what they'll do is, as soon as they have a contract to tear down the house or build a new infill, they'll do a builder lien on the property. But if they cancel the contract and the builder lien is still there, what does someone have to do?
I would make them serve them with a notice to prove the lien.
Okay.
Well, I mean, my first course of action would be just to call them. Say, hey, look, this builder's lien showing up on here. My client says that, this contract is canceled. There's not an issue here. Can you confirm? Yeah. Can we please have it discharged?
Right. And then with a letter from the builder stating they do not have an interest in the property anymore, that would suffice?
We would just have them discharge it.
Right. Okay.
Okay. So now we move on to some architectural guidelines. So if you've ever dealt with a new home purchase, you may have seen something related to architectural guidelines. Usually there will be a landscaping deposit or something to ensure that the ultimate buyer completes certain items. Once those items are completed, the buyer gets their money back. Sometimes this arrangement is registered on title. So in this particular case we see here, we have the developer, so in this case Aldrit, would register a caveat, and the home builder who built the home will build it according to the guidelines set by the developer. The ultimate buyer here was also required to complete a number of items, which they never did. So it's not a big deal if you're not selling your place, but it can quickly become a problem if you got a pending deal. So here, in this particular instance, we were required to hold back funds, and the seller had to get a fence built very quickly. They never even really realized this was a problem because most of their neighbors didn't have fences. Now, the problem was is most of their neighbors weren't selling, so it never even came up at that point. So in this case, what we do is, was get on the phone with the builder and the developer, see exactly what needed to be done, and I think it was a fence and a couple of decorative handles on the garage door and some shrubbery. Once that's done, developer, in this case Aldred, again sends an inspector out there, inspects the property to make sure everything's done, and then submits a discharge. So if I see something like this on a title, I'm going to pull the instrument as soon as possible and contact the relevant parties, so the developer and the builder, if I know who that is. And most of the time, it ends up that it's just an oversight that they forgot to discharge. And it's just a quick matter of a phone call. Oh yeah, we forgot about that. I'll send you the discharge right now. But sometimes, and as it was in this case, the seller really has to scramble to get things done. So if you see something like that show up on title, probably the best thing to do would be to pull it or contact whoever the lawyer is on file and see if they pulled it, or if you have any questions, ask them to pull it for you. Now, another type of developer caveat is sometimes we'll see an option to purchase. So here we have an option to purchase registered by Karma. Now, in some cases, there will be a caveat that it's part of a development agreement with the county or with the developer, and it'll almost look like an option to purchase, but it's not, and it's not coming off. It may even have wording that'll suggest there's some sort of option in there, and really what it is just to make sure that they follow this development agreement, and if they don't, then say the county, it's like the county of Strathcona or something, will have the option. But it would look a little different than this and wouldn't necessarily be a concern. In this case, we pull it, it actually is an option to purchase, and it's exactly what it looks like. So it gives the registrant an option to purchase and a first right of refusal on the sale. My guess is, in this particular case, this was registered when the developer sold the lot to the builder, and then it should have been discharged when the builder sold the lot to the ultimate purchaser. So in these cases, I call the agent listed on title, and we can usually get it cleared up fairly quick. So this kind of brings us to the end of the section on caveats and liens. Probably the most important lesson I would take out of this is that if you're not sure what something is, pull it. Pull it off spin and have a look, or have the lawyer pull it off spin to see what's in there, because sometimes it's cause for concern that should be dealt with as soon as possible. And sometimes it's not a big deal, and it can be dealt with fairly quickly.
Hey, Damien. So one of the common ones that we're seeing a lot of is a caveat or a lien for rent.
Okay.
I forget the exact terminology, but it's essentially.
Oh, okay. An assignment of leases and rents.
Yes.
Okay. So those are really, they're nothing. What they are is, every mortgage will have a clause in there that the lender, if you're behind, if this is a revenue property or you're renting a part of it and you're behind on your mortgage, the lender can approach the tenant and have rent paid directly to the lender. Okay, with a revenue property or commercial property, that's registered on title. That's the only difference. So once you pay that mortgage off, it falls off title. Okay. So you'll see it'll be related. It'll usually be with a mortgage, and it'll be the same, the same company. It's not really a concern from our part because, like I said, once we pay that off, our instructions to the lender are, we want you to remove the mortgage and we want you to remove this assignment of leases and rents.
Right. So when an associate is pulling title, and they see that, then they could safely assume the property's mortgage was done as an investor, like investment mortgage, and not as... That would be my guess. Yeah.
But sometimes depending on the lender, so some non-traditional lenders may want them registered no matter what.
Right.
But probably 95% of the time, if it's registered on there, it's because it's a revenue property.
Okay. Wonderful.
All right. Let's move on to some other security interests. So I got a couple here just to show you. The first one I have is a writ. And all this means is that there is a lawsuit against the homeowner. When the judgment creditor won, they received their judgment and registered a writ against the property. So if you ever have to sue someone or they have a lot of equity in their home, this is a good way to ensure that your debt eventually gets paid, because the property won't get sold or even remortgaged without this thing being removed. In this particular case, we can see that RBC won a judgment in 2011 against the homeowner. And by the size of this debt, my guess would be that it would be for a car loan or something. In any event, this, like any other debt on title, gets paid once with sale proceeds. So, if we're going back to our discussion about whether something's underwater, this is one of the things that we would look at. So I would need to know I got enough money to pay off this mortgage, and I got enough money to pay off this writ, or any other thing on there. So, some other things that can show up like this would be, a caveat for, back taxes, for instance, or condo fees. And those things all have to get paid off, and they all come into the calculation.
Does a writ get paid off before the charge, or is it after the charge? So the mortgage here is number one, it looks like, and then the writ is number two.
Yeah, so whatever's on there first. So I can tell you right now, I doubt very much. So this happened. So we got a mortgage registered in January, and then the writ's registered in November. I doubt very much when these people went to remortgage that any lender would touch it unless that was paid off, unless that was included in the mortgage, because they don't want to be so if they remortgage with, say, a different lender, that writ becomes number one, and banks don't like that. So that would most likely get paid off anytime they remortgage.
Okay, thank you.
Now, I guess kind of as an aside for that, there are a few things that doesn't matter where they are in title, they're going to take priority, and that's things like taxes and condo fees. So if you want to keep that in mind. And then finally, we got security interest related to fixtures. So generally you see these with the HVAC companies or those guys that go door to door selling furnaces and AC units on a monthly payment plan. It'll show up as a security interest in fixtures in the property. As with any debt registered on title, I'll call the lender, request a payout for the security interest. And once I receive proceeds of sale, I pay the debt and the interest gets discharged. In this particular case, we got a CIBC with an interest in fixtures registered for the exact same amount as the mortgage. So I would guess that this was probably some sort of purchase renovation mortgage. I'm not sure why CIBC would bother re-registering for the same exact amount, but I imagine that they had their reasons for this. And that is pretty much it for today. So thanks for hanging around, and what do we have for questions?
All right, so before we dive into the questions, I'm going to stop your screen share. Only me. Ooh, I'm going to change the view so we're beside each other. And then now, just going to pretend like we're going through a listing. And just hear what all the drop down stuff is. Oops, just wait. Let me get to this page before I share the screen.
Oh, I'm able to see this?
You will, yeah, you will be.
Okay. Okay.
Once I share. All right, can you see that, Damien?
I can.
All right, so when we click on here, restrictions. So this is typically restrictions of the property.
Right, yeah, some of those aren't going to show up on title. For instance, board approval for pets wouldn't show up on title, or unless, is that?
It says easement registered on title.
But like adult living wouldn't necessarily show up on title. Easements will show up, and they, it'll be for something like a road. Those will generally stay on title.
Okay. Historic site?
I've never seen one. I don't know off the top of my head. My guess is if it's a designated historic building, that would stay on there, but that's something I can look into.
No pets, that wouldn't be on pet restriction board approval, that wouldn't be on phone listing. Yeah, that won't be on restricted covenant building.
Yeah, that might be on there, and that even sometimes you'll even see something like that for architectural guidelines. So, you can only build this thing here.
Okay.
And that would stay on title, generally.
Sub to final registration?
What does that mean?
That's a great question. I think that means for
Subdivision?
new build, going to final registration, like switching from the land developer to the builder or to the home.
Oh yeah, I mean, that's at the end of the day, whoever's selling the property, that wouldn't necessarily, I mean, that's going to change because if you're referring to the ultimate owner, that would change, obviously.
Okay, but when we're submitting, so if someone's listing a condo complex as an example,
right,
it's under new construction, then that could be one.
Well, you guys would want to see that whoever the seller is the actual owner.
Right.
And if they're not, the one nice thing about the new pending registration queue is you'll see whether there's actually been, so sometimes you'll see the owner is not going to show up on title yet, because again, 3 months, and they want to get this thing sold. So you would actually see the pending registration, and you can pull that and see what it is. So that might be an issue where you'd want to know exactly what's going on there.
Right, and same with subdivision. So example, infill lot being subdivided in 2 or in a greenfield.
Yeah. So yeah, I mean, sometimes you'll see this with condos, actually, a lot of times, where possessions will take place before the condo plan's even registered. So technically the person's property doesn't exist, but it's in the process, and you'll actually take possession and you'll live there as a tenant at will for, I've actually had someone, we were acting for, God, depending on what land titles, 3-4 months, 6 months maybe. That's really on the outside, but certainly that's, again, something, if I'm reading that right, it would, the property technically wouldn't exist yet,
right,
until the subdivision is complete.
Right. Okay. Utility right away.
Yeah, that's going to stay there, and that's basically TELUS or EPCOR or whatever.
So what's because utility right away in the city typically isn't a major concern, but it can be still for some acreage properties, correct?
It could be. I think it would depend. Yeah, I mean, it can be for, and I've seen it come up for problems where, yeah, it can be a pretty big chunk of property sometimes. And the times where I've seen it come in, and I don't deal with a ton of acreages here, so you'll have to forgive me, but times where I've seen it is where, there's something built there, and you either have to remove it, or if it takes up a lot of space or a roadway or something, it can cause a problem with, any eventual buyer.
So what's the best way for an associate to protect a buyer when it shows utility right away?
In the city, just not much, and there's not much to do there. In the country, I would pull it and see how much space it takes. I mean, you can probably, usually you'll see also on an RPR, it may show it. But pull it. I mean, the best thing you can do if you have any question about any of these is pull the document and see what it is.
Okay. And 0 lot line, that wouldn't show on title, would it?
What is that?
It just means the house gets built right to the edge.
Oh, okay.
Yeah. Caveat on title, obviously shows on title, and non-smoking building would not. Okay. So I'm gonna now allow the participants, the attendees, to speak. So if anyone has any questions. Ooh. You're all muted when I bringing you up on screen here. So if you would like to unmute yourself and ask a question, please go ahead.
Yeah, I'll ask one.
Oh, go ahead.
Okay, Steve, go first.
Yeah, so with regards to the, like that stuff registered on title, like easements and utility right-of-ways and stuff like that. I think I probably agree with Damien that in the city, it probably doesn't, it represents not much of an issue, but I tell you, I pay attention to that when I'm out in doing farms and stuff like that. And you know, there was a lawsuit that comes to my mind that I read about taking the course. About a buyer that's, you know, got a buyer's agent got a buyer into a big chunk of land down south. And there was a utility right away where you couldn't build anything plus or minus, you know, 150 feet either side of center line. And this essentially this property was useless to build anything on at the end of the day. And the agent got sued and so on and so forth. So yeah, you got to pay attention to that. So I'm a firm, you need to pull that crap on title.
Yeah, certainly on in the country, I would. In the city, I don't, you know, like you say, Steve, in the city, I don't really pay too much attention to them because they're like a little slice of land that you can't build on the side of the property, but certainly in the country. And I've seen them where, like you mentioned, you know, where it's 100 feet either side or something, where it takes a big chunk of the land out. So if you're dealing with an acreage, I would pull it to see what's there.
And I even call the county too, and the people at the counties are pretty knowledgeable. They've corrected me and said, no, Steve, actually it's 150 meters. So that's 300 feet either side, which is even worse. So.
Samantha, your question?
Yes, I have also a question about utility right of way. So just looking at like my listings recently, all seem to be in newer subdivisions. That's the very first thing that I see on title for each of them. And I just double checked and I see that. And then I'm in a new subdivision in Glenridding, and the way that they're selling it is only one lot of 100 has a utility right of way. So I'm just wondering why there would be such a discrepancy, or what does utility right of way mean in that case, I guess?
Sorry, there's only one lot out of 100 lots that actually has a utility right of way?
Yeah, that's the way that the builders are selling it. But I'm looking at, yeah, it's weird. And they clearly show you where that utility line is, and it's just the big pie lot. But if I look at my listings, I'm seeing utility right away on almost every single one of them. And then when we're going and shopping, I'm seeing listing agents put nothing known on title, but I do see utility right of way listed as the first thing. So we should, it's kind of weird.
Yeah, and I think maybe I mean, yeah, maybe Alex, you'd be in a better position to answer this. Maybe they're putting that there's nothing on title because there's nothing that's non-permitted on title. Maybe that could be it, or.
Yeah, I would say that the person, I can't speak to all the listing, but if the listing should have it, if it's listed on title, my thought to the builder would be the person in the show home ad selling the community is just showing where the actual line is, but not necessarily what the city is putting on title, because a utility right away can also mean a line could be built in the future, if I'm correct. Right, Damien?
I'd have to see it.
Yeah. Right, but the term utility right of way can mean that it is for future use, not just current use.
Yeah.
Yeah, so they might be where the only actual utility spot is, but the city is saying, no, it's going through this whole section. And
I've never seen that. I mean, I guess you guys would probably deal with a lot more, Samantha, with these sorts of things. I've never seen. I guess I don't see any of the ads or anything, but that just seems weird to be like one person getting hit with everything. Or is an actual lot they were selling?
Yeah, and it's clearly labeled utility right of way, and it's like this big pie lot, and they're like, okay, you can't build anything along this line, right? But it's the only one in the whole neighborhood, and it's labeled that way by the developer.
Okay. Yeah, I would guess I would just pull those and see what's in there.
Okay. Can I ask another question?
Ask away.
Okay. So you're saying on title, the items registered are in order of, sorry, I'm trying to think of the word, the way that they would be paid out, correct?
No, they're registered by date.
By date, okay.
So priority is date. Now, but with a few caveats there, and the caveats in the sense that There's a few exceptions, and some things are always going to take priority. So like taxes, for instance, will always take priority no matter where it is on the title. But other than that, it's all by date.
So in the event of, and I'm not sure if you can answer this, of a foreclosure listing, so these buyers are signing a Schedule A, it usually is, stating that they're not going to pay for taxes, or they do have to pay for taxes, but then you're always reassured by the lawyer that no, don't worry, taxes are going to be paid by the bank. So they sign a document saying that they're responsible for taxes. The lawyer confirms that they won't have to pay the taxes, which has always been the case. But what if it was the event of a shortfall? Would the buyer have to pay taxes?
Yeah, so foreclosures, everything's by court order. So I don't think I've seen, even I think the most recent foreclosure schedule they have seen is for a condo, and even though they'll scratch out that we were responsible for condo fees and assessments until closing day, it was still in the Schedule A that they were responsible for those things. So I would be a little worried if I saw one that said, seller's not going to pay back taxes. Because that would be, the city would never stand for that. The city's going to want to get paid first, and the condo corp, for that matter, would want to get paid first. So I would imagine that the order would say, the judge's order, and you can always pull that too. It'll say back taxes paid first, condo fees paid, and then whatever's left over goes to the bank. And we're not really concerned about a shortfall as much there, because it's actually the lender. I suppose the ultimate person that got foreclosed on would want to see as much come out of that as possible. But if the lender is accepting an offer and they're going to take a loss, then they know that going in.
Okay.
Does that make sense?
Yeah, typically on a foreclosure, shortfall doesn't matter, because if it's the bank who is the seller and the charge, so they'll accept.
Yeah, unless there's a lot of sometimes if there's a lot of say back taxes and there's not a lot of money and there's other interests in there, they may get into a fight about that. But a typical deal, like Alex, that's not something I'm too concerned about.
Okay, so have you ever seen a case where they didn't pay the back taxes?
No, I don't think I've seen in schedule, and maybe I'm just going blank here, but I don't think I've seen where they actually say on the contract, because usually the judge's order will say they have to do this, 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 and this. So I guess at the end of the day, what's on the schedule doesn't really matter to me. It's what's on the judge's order. Okay,
that makes sense. Can I ask another question?
Keep going, Samantha, keep going.
Okay. Encroachment agreement. So that would be a caveat on title. So when we are, so that's already registered. So sorry, Alex, if this is more a question for you. So when we're listing, we have to put that in a term, right? That the buyer is to accept the RPR with encroachment agreement. Like that's something we have to get them to accept, correct?
Well, we'll get Damien to kind of explain encroachment agreements a little bit, and then how they kind of play with an offer and what the process is.
So I can't tell you, I can't speak for how they're going to play. Well, I guess for an offer for you guys, but if it's registered on title, you're probably going to, if you're listing everything that's on title, the encroachment agreement is going to be on there, right, in your listing. Mm-hmm. So I don't know if it's that much of a concern because it's there. Where it becomes a bit of a concern is on an RPR, if it shows up that there's an encroachment, especially with the city compliance, because sometimes you'll see it where the compliance report will say, oh, there's an encroachment. The city's always willing to sign them. Well, I've never seen them not. I'm sure there are situations where they won't sign them, but it'll say actually on the compliance report, encroachment agreement, we'll do it for the $500 fee plus, I've seen it $300-400, and I've seen it $15,000 depending on how big the encroachment is. So sometimes in a seller's case, it might be worth, and usually you'll see it'll be a fence encroaching on the back lane or something. It might be worth just tearing the fence down or tearing the back of the fence down and rebuilding, because if they're going to charge you 20 grand or 10 grand for the encroachment agreement, then that's something to think about. Where they also pop up is if it shows up on the RPR that you're encroaching on the neighbor and there's nothing on title. What I'll generally do is we'll prepare an encroachment agreement, contact the neighbor. This is a real pain. and get them to sign it. And usually they're pretty good about it. They'll sign it without trying to squeeze you or get any extra funds out of the seller. But sometimes that can be an issue. I don't know if that answered your question or not, though.
It does. And if I list caveat on the MLS highlight sheet, is that my duty to be telling them that there's an encroachment agreement, or is that the buyer's agent supposed to be going and looking at title and figuring out, like, is that something that they have to accept if it's already registered?
So, yeah, so if it's already registered, it would just transfer through with the sale, correct, Damien?
Yeah. Yeah, depending on what the encroachment agreement says, because some of them will fall off when there's a transfer.
Right.
But where you want to actually get involved is sometimes you'll see, say, if you see an RPR and there's an encroachment on the RPR with, like, say, the neighbor, or even the city for that matter, because the city's not going to come and say, tear down this fence. All you're going to have is a non-compliant RPR. So what you guys can do sometimes is just put in there, buyer to accept encroachment.
Okay.
Not encroachment agreement, buyer to accept encroachment as is.
Thank you. And at what point would it not be transferable?
If it says in the encroachment agreement that it's non-transferable.
Okay. And that would
So
usually
if I'm drafting them with say between neighbors, we're going to put in there that it's transferable and it stays as long as this thing is there. So if they tear down the fence, encroachment agreement's done. They have to build on the property line, or you do a new encroachment agreement, but generally they'll stay. Sometimes when you see the city do them, they'll fall off.
They want their money with the next homeowner.
But I don't think, I don't think I've seen too many situations where it's become a major issue with those. So, really at the end of the day, you just look at the agreement and see what it says.
Hi, Damien. It's Corey Cooper. How you doing?
Good. How you doing?
Good. I just had a question for you. I'm kind of working on one now, but they've agreed to knock some money off after the inspection, right? And
Yep.
But we want to put on there because of that, they're taking it as is, where is at time of inspection, and accepting the seller's personal belongings and the unattached goods, right?
Okay.
So in other words, okay, we're going to knock some money off for that, but you got to take it as is. Don't come crying back for anything more because you've done your inspection, done your due diligence. We don't want to hear from you again.
Right.
So would that take care of it if we put that in 9.3 in the terms?
I would put in there, when I do that, I would put seller to take property as is, where is, and then I would scratch out everything related to any kind of representation or warranty related to the property.
Yeah, I don't want to go doing that. I was told the terms supersede anything else, but I could put and no warranties or representation.
Yeah, no, you could certainly, my thinking is that just putting as is, seller or buyer to take the property as is, where is, no representations made would be enough. For me, I like to make things absolutely, no doubt.
Because at time of inspection, right? Because they don't want to go in there and see there's a big hole in the wall that wasn't there when they did the inspection, right?
Yeah, or however they accept that term. I mean,
yeah.
Right.
You just
So
want to
let's
make
get
sure
back
that
on,
they're.
sorry, I'm going to interrupt. Can we get back on track to questions related to titles?
Sorry.
We definitely reach out to each other about that question because it's a great question, but
All right. Okay.
this is related to titles.
Go ahead.
So we have another question here. How does land titles being 3 months behind affect a person's ability to quickly flip a property? Example, someone bought in Jan, when prices are lower, closes in May, and wants to sell ASAP while market is still hot.
Okay, so and I actually just have one of these right now, so it's probably a pretty relevant question for me anyway. But the problem for me as a seller's lawyer is the original seller's lawyer promised the original buyer's lawyer that they were going to remove registrations from title. And I don't have that promise though. The other lawyer does. So I actually have to call the other lawyer and make sure, and maybe even see a copy of the original trust letter, making sure that that promise is in place. As far as the actual transfer itself, that would be more of a, if I'm acting for the seller and the buyer's lawyer, the subsequent buyer's lawyer. So we're talking, we got original seller, original buyer, and then This guy's flipping to the new buyer. The new buyer's lawyer has to be comfortable with the fact that the actual person on contract is not on title yet, but they can see that there's a pending registration there. So they can see that it's in the queue. Sometimes, you know, where there an issue will pop up is if it gets bounced for whatever reason. So the original transfer gets bounced because there was an error of some sort, and that kind of, you know, goes down the chain, and we have to get all that stuff fixed. But from our perspective, or from my perspective, acting for the seller when they're flipping it, my big concern is to make sure that there is actually a proper promise in place to remove the original mortgage from the original seller. And that's where my concern is. And then the other thing I'll do is I'll contact the lawyer for the subsequent buyer and say, this is the situation. Are you comfortable with this? And that will actually come up a lot too in estate matters. You know, so we can get an order to transfer a title from a deceased person to the estate really quick, in, you know, a week. But then that transfer takes about 3 months. So, and I've had these before, and I call the other lawyer and say, hey, look, this is the situation. We got an order. We're submitting it. Are you okay with moving ahead? Yeah, no problem. Or, yeah, we have a bit of a problem. Can we do a tenancy or however? But usually it's not a problem.
Does that answer your question, Suzanne? Perfect. We have another one. So life lease registered on title. Son and mom bought house from father. Father lived in house, now suffering from dementia and is in extended care. What needs to be done to remove the life lease?
You would have so you'd have to look at what the agreement says. So the agreement most likely might like the life estate may say father gets to live there until he can't. And then if that's the case, then we would just do a discharge for it and have one of the agents sign, basically.
Okay. For those that don't know, can you explain what a life lease is?
So a life estate will be, you know, sometimes you'll see them with estate matter, like estate. When I say estate matters, like wills and estate matters. Basically, you're giving someone the right to stay on a property under certain conditions for their life or until it expires. So we'll put something like they can stay on there until they die or they move into a home, for instance. So in this particular example, what would most likely have to happen is we would have that person's, if suffering from dementia, I'm assuming they may have a power of attorney. We'd have their attorney sign off on that.
And if I remember correct, so my parents passed away. I inherit the house with a life lease for me in it. I'm not actually able to sell the house with the life lease on it, correct? Or is that just a trust?
That would be a trust. Like, it would depend on what's in the agreement. So if you see a life estate, you can pull it and see what's in there.
Right. Okay.
Okay.
Because
but
I guess
you're in your
situation,
situation,
estate with a life lease for the child. Yeah.
Yeah. So if that case, it might be that things were left in trust to be held by this trustee for whoever's benefit. And then the trust agreement or the will or whatever the case may be will kind of lay out the terms of that.
Okay. Did that answer your question, Jeff?
Yes, it did, Alex. Thanks.
Perfect. Perfect. Any other questions by anyone else? Oh, sorry, another one. Can a lien be transferred from one property being sold to the property being bought? Father and mother lent funds to son and daughter to do renos and part of the down payment, and now are expanding family and purchasing new home. Mom and dad are not wanting funds paid out at this time. So what is the best way to deal with this? Pay out on sale or? Jeff, can you just ask the question and maybe explain the?
So basically what it is mom and dad lent money originally to buy the first house. So to satisfy the mortgage, improve the mortgage funds, they went and lent them money afterwards. But because mom and dad are getting a little older, to protect the interests of the rest of the family members, they placed a lien on the property so that if something happened to them, the money's registered on there. So now they're expanding, wanting to move to a bigger home. they still have this. Mom and dad are saying, no, we don't need the money right now. You guys keep that money. Go ahead and do it. Whichever way works the best. So
Yeah, so I think I kind of gave, so they want to place a lien on the new place.
yes.
Yeah,
Yeah.
so the old one would be discharged, you do a new one.
Okay. So it can be just bang, bang, just transferred on the new title. Or on
Well,
the
not
title that
transferred,
they-
it would be discharged and re-registered. Now, the only
Registered,
concern
yeah.
I would have with that is, what does the bank say? You know, so what you're gonna want to do is you want to get the bank on title first, because the bank's not gonna like being second to anything. So you'd have, and I don't know how did they register it? Do you know, was it registered as a purchaser's interest or?
I think it's just a lien, I think, or,
But
I
for,
don't
so
know.
there's, yeah, so you know, I'd want to see what it's registered as.
okay.
Whether it's registered as a second mortgage or like an agreement charging lands like we saw,
Mhm.
or whether it's registered as something else. I'd want to see what that is, and you would discharge that once the new property is bought, and if they're using a mortgage, all that stuff is done, then you can slap it on there. But if the
Okay.
bank sees that before they're on and they're not in first position, they will not like it.
So it's do it after the purchase has been done and through the mortgage, everything. So, yeah.
Yeah,
Okay.
yeah, and it really would depend, like I said, on what it is. Like my
What the
guess is they
wording.
did maybe an agreement charging lands.
Okay. Thank you.
No problem.
Any other questions? No, it doesn't look like it. Damien, we thought it would be hard to fill up an hour, but look at that.
I know, right? I was like, oh God, what am I gonna do for an hour? Hey, thanks a lot, everyone, for coming out. And thanks, Alex, for having me. It's been a pleasure, and actually going through this, I was like, holy crap, right? You know, you kind of learn a bit yourself when you're going through all these old titles and stuff, finding stuff. So thanks a lot.
And thank you, Damien, for always being willing to do these webinars for us. I want to get you, go to your presentation again. I want you to share your screen just with your contact info, just for one last one. So everyone can see it just before we head off.
One sec here. There we go.
All right. So everyone, this is Damien's contact info. So please do reach out if you have any questions or concerns, or if you think of a question that wasn't up today.
Damien,
And honestly, anytime.
Damien,
Sorry?
do you still go to the people's house if they need?
I do, yeah.
Or to
Yeah.
meet in a coffee
Yeah, the
shop?
only thing, I'll tell you, the only thing I'm really kind of slowing down on right now is condo docs. A lot of times I'll do those during slow times to get people through the door, and we are getting to the point now where we're pretty swamped. So it's tough to fit those in, but certainly I'm willing to meet people wherever, whenever.
Okay, good.
Wonderful. Well, thank you again, Damien. I'm going to hit the stop record now.